It's time for The Verdict. The Verdict is a lively discussion of current events and legal issues pertinent to Oklahomans. The Verdict is hosted by Kent Myers and Mick Cornett. The Verdict is brought to you in part by Betcher, Martin, Jean, and Jackson, when hurt people need help. Betcher, Martin, Jean, and Jackson in Ponca City. It's time for The Verdict.
And welcome once again to The Verdict. I'm Mick Cornett. Partner here is Kent Myers. He's one of Oklahoma's top legal experts, and another exciting show coming up for you.
Well, you say that about me every week, and I know it's not true, and most of our viewers do, but today we really do have one of Oklahoma's top legal experts. The news has just been full of criminal trials, but they aren't the typical type that we see. They're not the Terry Nichols trial being the exception, of course, but we're not seeing high-profile criminal cases of the rape, murder, arson, etc. type. What we're seeing are white-collar crime trials in the news. We're seeing Tyco, 6-month trial, just had a mistrial. We're seeing Martha Stewart running through a trial and getting convicted. We're seeing the CFS trial over in Tulsa with Bartman ended up being acquitted, Enron and the like. And today we're really pleased to have a guest that's been involved in one way or another with Martha Stewart, with the CFS, with Enron, and many other high-profile white-collar crime defenses. And I think what we're going to do on The Verdict today is find out how the defense of a white-collar crime may be different than the defense of, a dirty-collar crime, but in any event, a non-white-collar crime.
Should be an interesting show. We'll meet our guest when we return. You're watching The Verdict with Mick Cornett and Kent Myers. And welcome back to The Verdict. Mick Cornett with Kent Myers, and Kent's going to introduce our guest.
Our guest today is Drew Neville. Drew is an attorney with the firm of Hartzog, Conger, Kaysen, and Neville, a 30-year trial lawyer, a longtime friend of mine. He's been both a prosecutor and a defense lawyer. He was an assistant U.S. attorney for a number of years before going to the other side of the table and representing criminal defendants and civil defendants as well. He's been involved in a number of high-profile cases, including the Enron case, the tailhook Navy scandal, CFS case, U.S. versus David Hall, when Governor Hall was convicted in federal court. And he's been involved in one way or another, not officially, but in consulting roles within the Martha Stewart case. He is a fellow in the American College of Trial Lawyers, and I don't mind saying that he is recognized as the premier white-collar crime defense lawyer, certainly in Oklahoma, if not beyond our boundaries. Drew, thank you so much for giving us your time.
Well, I'm flattered to be here. Thank you.
All right, Drew, let's pretend it's your first meeting with the client. It's pre-indictment. Do you ask your client if they did what they're accused of doing?
Well, in white-collar cases, usually, Mayor, you don't have to ask that question, because most of the time in a white-collar case, the client has performed or done the transaction, and the real question is, what was the intent to do? For instance, most issues in white-collar cases can involve issues of accounting, and usually there's not a dispute or issue of fact over whether the transaction in fact took place or whether the transaction was actually booked. So whether the client, quote, did it is usually not an issue. It's the intent with which it was done.
Well, typically you'd be using, you would be going against the government in a
Yes.
lot of white-collar crime cases. Do you cooperate with the government? If they want information, do you want to cooperate with them?
Well, there are two different theories on that. Some defense lawyers have the bunker mentality aspect of let's hunker down, bunker down. We won't say anything to the government. We won't cooperate with the government. I would suggest that may not be the best way to proceed. I believe in an open dialogue with the government. I do believe in cooperating with the government because I think that generally that serves your client in the best way, especially if you're representing someone that you think has a very viable defense. I think keeping lines of communication open and cooperating in a professional manner best serve your client, and that's generally how I proceed.
In certainly federal cases, they usually don't proceed without or can't proceed without a grand jury indictment, and that I suppose always brings up the issue about should your client, when subpoenaed to testify before a grand jury, or perhaps given an opportunity to testify before the grand jury, should your client walk in there and testify in the federal grand jury or in the state grand jury?
Well, I think the pre-indictment stage is critical to this process, and one thing that you must do in defending any white-collar case is determine whether your client has so-called target status or doesn't have target status. Target status sometimes is loosely defined as a client who most likely or probably will be indicted by the federal grand jury. If in the pre-indictment process you determine that your client has target status, you're probably best served by not having your client testify in the presence of the grand jury. If there's something less than target status, then your decision really is more difficult and requires more investigation. So whether your client testifies or not depends upon the status that you ascertain they have prior to the grand jury.
Now, sometimes the lawyers and yourself are allowed in the grand jury room, and sometimes they're not. Can you tell us when you're able to get in and when you're not able to get in?
Well, in the federal court system, the lawyers are not allowed into the grand jury room. The federal prosecutors who are handling the case are entitled to be present in the grand jury room, as are the investigating agents. But the defense lawyers themselves, or even lawyers representing witnesses, are not allowed in the grand jury room. Now, your client is allowed, upon being asked certain questions, is allowed to leave the room and confer and consult with counsel even while a question is pending. But defense lawyers are not allowed in the grand jury room at the time
under the federal
system. In the state system, it's different. The grand jury, you can attend a grand jury session with your client.
Does that make a difference in whether or not the witness testifies? I mean, would you be more likely to have a witness testify in a state grand jury proceeding than in a federal, simply because you could be there?
Kent, I don't think so. I don't think that's outcome determinative in that decision. I think the key issue here is whether your client has target status or doesn't have target status.
Okay.
A white-collar defendant may be more likely to have resources to put up an elaborate defense. You get into jury selection. Recent book and movie, The Runaway Jury, seemed to show it was an elaborate process with a little bit of espionage thrown in there along the way. Tell me about jury selection. Tell me about the expenses and whom you would hire to come in and conduct jury selection.
Well, there are several very fine jury consultant firms all across the nation. In federal court, which is where most all of my experience is, the jury selection process proceeds very, very rapidly. It's difficult to use jury consultants in the federal process, I believe, because you don't have the time to actually confer with your jury consultants during the actual selection process. I'll give you a good example. In the David Hall case, tried many years ago, the jury was actually seated in about 45 minutes. So the use of jury consultants, at least in my experience, usually involves having these consultants identify a profile or help you identify a profile of someone who you think is on the jury.
Just basically demographic information?
It's demographic information. Hopefully it's employment-related information, obviously age-related information. It's easy to search public records to see if they've had any previous civil or even criminal exposure. Those kinds of investigations are perfectly proper and they're done, and hopefully you'll have some idea of who you want on your jury at the time that you have to pick your jury.
Let's take a break. Drew Neville is our guest. We'll be right back. This is The Verdict. Welcome back to The Verdict. Mick Cornett with Kent Myers. Our guest this week is Drew Neville. He's a defense attorney specializing in white-collar crime, and you've been involved in really the highest profile white-collar crime of this year has been the Martha Stewart case, and you've been involved at some level in that. Tell us what you can.
Well, Martha Stewart has actually been, through a good client and a good friend, a social acquaintance for some 4 or 5 years, and over the last 8 months or so, I've had several conversations with her concerning the nature of her case, and both the criminal case as well as the civil case. And I'm flattered to have been consulted by her and to have been able to visit with her. I have to say I haven't been retained in any of those cases, at least at this point, but they've been more from broad overview strategical analysis than anything else.
But the jury's still out, if you will, on what involvement you might have.
The jury,
hereafter.
yeah, that is correct, and of course she has pending right now a very key motion that could grant her a new trial, and so we'll see where it goes from there.
And I presume if that motion gets sustained, that'd be a good thing.
Well, I would hope that I would be considered for that case. I would have loved to have had it in the first place. I think she had a tremendous defense in her case, and I still think she does have a good defense. And we obviously wish her the best.
Let me ask you about how you deal with a white-collar defense that may be different than how you deal with a typical criminal charge.
Well, the white-collar cases generally are extremely complex, usually involving difficult, detailed financial-related transactions. Insider trading is not always as simple as it may sound, because it may involve market analysis and so on and so forth. Accounting cases that involve alleged criminal activity in complex transactions like you see in the Enron case require experts to come on board as soon as possible. So these cases require a lot of hands-on attention early because of their complexity. They require a lot of outside consultants by way of market experts, accountants, even lawyers in cases.
Drew, let me just throw out a compliment to you, but it's one that those of us that have been involved in the practice here a while know to be true. You have an extraordinary ability to make very, very complex financial transactions understandable to a lay jury, perhaps jury made up of people who, in some cases, haven't completed high school, maybe had very limited business experience. What do you try to do as a trial lawyer to make very complex situations understandable to a lay jury?
Well, being the fine trial lawyer that you are, in the difficult antitrust cases you've been involved in, you know that is hitting the nail on the head, is how to simplify that process. And it just takes a lot of time and a lot of work and a lot of thought process, but you are constantly searching for a single or maybe even a two-theme approach to your case that strips out of it legalese and accounting language, looking for something simple that the everyday juror can relate to. It is difficult taking concepts such as off-balance sheet transactions or special purpose entities and telling a jury what they mean, but that's the key to the defense of these cases.
Do you handle a celebrity white-collar crime case differently than you would handle a non-celebrity white-collar crime case?
Well, you know, I haven't met too many CFOs or chief executive officers who don't view themselves as a celebrity. So there's not too much difference. I would say that when you're defending or dealing with somebody like a Martha Stewart or like a Kenny Rogers or a Jerry Lee Lewis or others that in the past have been in the news, that type of celebrity profile generally carries with it handlers or people that are constantly around that celebrity. And sometimes piercing that to even have meaningful conversations with your client can be difficult. The trappings of that are difficult. The press and media attention associated with that can be difficult. And usually in other types of white-collar crime cases, you don't have that.
I noticed in the Martha Stewart trial, and I'm not going to ask you to comment specifically about this tactic there, but I noticed that several celebrities not on trial showed up in apparent support of the defendant that was on trial. Do you have any feel about bringing somebody into the jury or into the spectator section that is a high-profile person themselves?
The lawyer's going to have tremendous concern about that, and it's something usually that the lawyer really cannot control. I doubt if Bob Marvello could control whether Bill Cosby showed up at Martha Stewart's trial or not. The concern you have about it, and the concern I've had about it, is that the jury obviously is going to recognize that individual. That individual is going to sit on the celebrity side of the courtroom, of course, and you get concerned about the jury believing that they're somehow being intimidated with this celebrity process. And I am always very discouraging of that, and really don't want to see that happen in a case, but you can't control it. And when I mentioned earlier about the trappings that go with representing celebrity clients, that's definitely one of them. I actually was in a trial one time when Muhammad Ali came in and sat on my client's side of the courtroom. Now, that had a positive effect in this case, I think, but you know, you're concerned about it, and I discourage it.
Do you think most white-collar defendants should take the stand in their own defense? Do you have a rule on that?
Well, I actually do. I think that usually the white-collar client is very intelligent, educated, and articulate. And I'm not one that believes in the defense of a case for appellate purposes. I like to see a case and try to try a case that we're going to win at the trial. And it's always been my suggestion or my philosophy that winning at trial in a criminal case does involve putting your client on the witness stand, and my bent is always toward my client testifying.
Is that the key part of the trial if you do that?
It can be. And most often in white-collar cases where the areas are gray, as an example, a CFO who may rely on accounting treatment for how a transaction is treated, the government contending that transaction was fraudulent, and the CFO contending I relied on my accounting people. If you don't put your client on the stand, it's very difficult to prove reliance on the expert, reliance on the accounting. I think your chances go up immeasurably if you are able to put on your client, and that's what I look to do.
Well, the jury looks forward to that, I know.
Yes, they do.
And
they want to hear from the defendant.
And if the defendant doesn't show up, the jury may, and they're not supposed to, but they may get the wrong impression.
Well, I am not a believer that there is a presumption of innocence under the law, but I think the practicality of it is that jurors all throughout the trial want to hear from a defendant, expect to hear from a defendant, and you've made your task much more difficult if your client doesn't go on the stand.
Yeah, we're about out of time. Just one brief question. Cameras in the courtroom. What do you think about it generally, and would you like it in the white-collar case?
I'm opposed to cameras in the courtroom. I think it's a step toward demeaning the process. I think it injects something into the process that really is unnecessary. I mean, obviously the public has a right to know what goes on in these important proceedings, but you have to balance that against the process and the dignity of it, and I'm not sure if cameras in the courtroom take a step toward that.
Okay. Drew, thank you for coming on.
Thank you for having me.
Thanks,
Drew Neville, Oklahoma City attorney who has made quite a reputation for himself in white-collar crime, and defending white-collar crime, I should say. We'll be right back. Kent and I'll have a final word after this. Welcome back to The Verdict. Mick Cornett with Kent Myers. That was a very interesting guest today.
Yes, Drew's been well known for many years as an exceptional trial lawyer, and he has an ability to click with the jury in ways that many lawyers do not. And I think that serves his clients well, both from the standpoint of getting a case put on effectively and enhancing the likely outcome. By the way, happy Easter
Thank you.
to you and your family. Are you going to hunt Easter eggs?
We will. We hunt Easter eggs
on
every
the
year.
front lawn of City Hall or something?
No, this will be a family-oriented event. We
good.
will be out at City Hall.
Well, let me tell you just a little bit about what's happening next week. Next week we're going to have a debate, a good old-timed debate, and we're going to debate whether or not our workers' compensation system should be reformed. We've got two good guests that are prepared. They'll be ready to get after each other on some of the most significant questions involved in workers' compensation, and I invite you to join us for that show. I think you'll find it very interesting.
We got a lot of good shows coming up, so I hope people will stay tuned and go to our website, theverdict.tv, and you can go there and tell us what topics you'd like to see discussed on a future episode of The Verdict, or tell us what you think about a previous show that we've had on The Verdict. We'll see you next week, Sunday, 9 o'clock, right here on KSBI. For Kent Myers, I'm Mick Cornett. See you next time.